Aye. Yep. Okay. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Okay, good morning. Welcome to the First District Court of Appeal. We have one case on the docket today. It is Joshua Crawford versus the State of Florida, Department of Corrections, case number 213783. Counselor for the appellant, you may proceed when you're ready.
May it please the court? I'd like to reserve 5 minutes for my rebuttal, please. My name is Ashley Richardson, and I'm here representing Joshua Crawford in the appeal that's currently before you. There are really only two issues with this case. We see them as relatively straightforward. The first is essentially procedural, whether or not the court abused its discretion by striking Mr. Crawford's declaration below. The second is actually getting into the meat of the summary judgment motion itself as to whether or not he experienced an adverse employment action following his protected reporting. So taking those in order, just as a brief background on the procedural issue, on November 4th, 2021, Mr. Crawford executed his declaration. There's no dispute that that's the actual date that's on the executed version of the declaration. On November 5th, to comply with the new version of Rule 1.510, with the 20 days, we filed the response in opposition to summary judgment, as well as the documents in support of that response in opposition, which included, unfortunately, the unsigned version of that declaration. Following,
let me ask you just about the timeliness. If that was filed on November 5th, when was the hearing scheduled?
I believe it was November 21st.
And was that 20 days?
There's been no dispute that it was either, I honestly was not the counsel below whether or not there was an agreement or it fell on a Monday. I don't quite remember where the 20 days was. The only issue in terms of timeliness was the actual declaration itself. There's been no issue before the trial court or at any other time as to whether or not the remaining portions of the response were considered timely. So my understanding was that the 20 days would have fallen on a Saturday, so I believe it was pushed to the following Monday, was my recollection.
As to the substance of the declaration, what was in it that wasn't in the exhibits that were attached to the summary judgment motion or to your response, as far as the deposition was there? And I know that at the hearing,
Right.
You talked about the various elements that seem to be covered by the declaration. So what is the harm here?
For the primary difference between sort of the basic deposition testimony and the affidavit is that the declaration, goes into greater detail about the actual what would support a finding of constructive discharge, that prisons are incredibly dangerous places, that being ostracized by your fellow corrections officers could be an incredibly dangerous, even life-threatening situation for a corrections officer who's essentially walking into the lion's den on a daily basis to do his job. If he can't rely upon the support of his fellow officers, what ramifications could that have on his life and safety? He also goes into greater detail about each of the acts of retaliation that were taken against him, primarily by Lieutenant Patrick. Names he was called, reassignments, his hospitalization for the physical manifestations of anxiety. Those just weren't explored in great detail in the deposition. And to properly respond to defendant's motion for summary judgment, just further explanation was needed in the declaration. Those facts are critical to the actual findings, sort of the second issue that I mentioned of whether or not he experienced an adverse action or a constructive discharge. So striking them really decides the case on a technicality instead of the merits of the case.
Okay, and we can turn to the merits shortly. Is there anything else you wanted to talk about vis-a-vis the motion to strike, the procedural matter?
There's nothing other than in its answer brief for the first time, the department actually mentions that this isn't necessarily an issue of mistake or excusable neglect, but is one of not knowing the rules, which was not brought before the trial court and isn't actually the issue at the moment. We filed all of the other documents timely. It was just that this was inadvertently the wrong version was filed. So that's really the only additional argument. So turning to the actual constructive discharge, admittedly, there is not, and unfortunately, a case on point that would support our position outright, that the threat to Mr. Crawford was severe enough to justify a finding of constructive discharge. But there can be no real dispute that a prison environment is a very different work environment than what most of us go to every day. If I accuse the girl in the office next door of stealing office supplies and she calls me a snitch, I'm not worried about getting beaten in the parking lot, hopefully, at my job. Whereas in a prison environment, being labeled a snitch is a very real, not made up for TV situation. We cited a number of cases about Eighth Amendment violations, which again, it's a different trajectory than what we're dealing with the actual corrections officer, but our position is that if the severity of being labeled a snitch in that closed, incredibly hostile environment of a prison is enough to trigger Eighth Amendment violations for the inmate, the officer should be afforded some kind of consideration for the fact that he literally has to walk through those doors that are then locked behind him and exist within that inmate population. And that being labeled a snitch is so severe that it actually triggers constitutional protection for the inmates themselves.
So is that the sole focus then of the claims of retaliation? They come vis-a-vis the threats by the inmates? Because the complaint alleges numerous other potential adverse employment actions, but I didn't see where those were actually relayed to the Department of Corrections so that they could remedy them.
Right. So in terms of informing the department, he began to file written incident reports, which is sort of the reporting structure within the prison. Anytime anything happens, whether it's from an inmate or from a corrections officer, we file an incident report. So after the harassment by Lieutenant Patrick and others began, he began to file incident reports noting that inmates were calling him, a snitch.
But did he file any reports reporting the harassment by his supervisors?
I think he mentions Lieutenant Patrick in all of those, but I don't know that it was specific to, Lieutenant Patrick is incredibly high up in the reporting structure, so it was essentially that his harasser was representative of the department. But I believe the only written reports include the word snitch. And then he also was disciplined for having to go to the hospital following that, like I said, the anxiety that sort of triggered what he thought was a heart condition ended up, I believe, being a panic attack. And I believe he prepared a response to that of the disciplinary action that he suffered.
Now, walking through the timeline, the incident where he had to go to the hospital, was that before or after his name came out in the public?
It was after, I believe.
After?
Yeah.
Okay.
And regardless, whether it was publicly known, I believe it was known within the facility that he had engaged in that sort of behavior, or the reporting, and being part of the investigation. So Lieutenant Patrick knew that he was involved in all of that, and then began.
So it seemed to be a month before that happened, before the public release and before what's claimed in the complaint, where things started going downhill.
It's some of the timeline is a little bit muddy in terms of exactly who knew what and when, but Lieutenant Patrick is sort of the bad actor in all of this. And to get back to your original question, which will sort of answer yours as well, there were additional acts of harassment, like you said, the having to go to the hospital, being called derogatory names, or being ostracized from his coworkers, which we believe sort of support a secondary finding of a hostile work environment retaliation claim, which can be used to show an adverse action. And then there's the side issue of the constructive discharge being brought about by just his general fear for his safety every day.
But so the claim of the retaliatory hostile workplace, was that pled in the complaint, or was it just a constructive discharge case?
I believe he goes into all of the details about that he was forced to resign, essentially, but that it was as a result of all of these different actions sort of culminating in a hostile work environment. I don't believe that it's just a whistleblower claim. There's not a separate hostile work environment whistleblower claim. It's all under the same count, just a single count complaint. But we did raise it before the trial court, and I believe her response was that just the actions didn't rise to the level of a hostile work environment, but a lot of that was based on the fact that much of his evidence was stricken when the declaration was stricken. So again, I believe the primary argument here goes to whether or not the work environment would be considered, whether a reasonable person would consider that work environment to be so severe and hostile that they would have no other choice to resign. And as I said earlier, in the context of essentially any other position, that's probably unreasonable, that you have been labeled a snitch, or that someone has reported something on you, or that you're generally not liked around the office. you're not going to work every day in fear of your life. And that is what, in his declaration, Mr. Crawford testified to. And there's other evidence to support that, other corrections officers that said if you lose the support of your fellow officers, you are essentially a sitting duck in a prison environment.
Right, but there's cases that distinguish between prisoner conduct and, officer or DOC conduct, because prisoners, by the very nature of the reason that they're in prison is, just the environment is different and the expectations are different. And I think you mentioned that this is a case of first impression, and you
Yes.
haven't found any case similar to what the facts are here.
Yeah, unfortunately, I haven't found a case that's similar to the facts here. So we're sort of using that to essentially show the severity of what being labeled a snitch would do in the prison environment, in that other courts have found that when it's applied to an inmate, it rises to the level of an actual constitutional violation, not necessarily to show that the two are identical, but just to show the severity of it in that specific work and life
Right.
environment.
And what, if anything, should we glean from the fact that he was labeled a snitch or allegedly labeled a snitch because he was actually snitching on a fellow officer that was, so in an argument protecting the inmates?
Correct.
in that regard?
I'm honestly, that one's a little bit more difficult, but at the same time, it's hard to say exactly what an inmate knows or doesn't know versus what goes through the prison gossip network. Whether or not the inmates knew the specific details that he ratted out another officer or ratted out an inmate, it's largely irrelevant. It was the label and the fact that he was experiencing threats from the inmates, like you better watch your back, things of that nature. So it's really what he did is less important than the response that he received from what I think everyone would agree is a dangerous population. And I see that my time has expired, so.
Any further questions? Okay, thank you, counsel.
Thank you. May it please the court. My name is Tom Thompson. I'm here on behalf of the Department of Corrections. I would ask that you affirm the summary judgment that was granted. Initially, I wanted to raise the issues about the declaration or an affidavit. It was the Supreme Court has established rules that have dates, time frames where you've got to do stuff 20 and 40 days. One of the reasons that this was done was to stop gamesmanship. I was a lawyer. We've all been lawyers. Things happened the day, when it said the day before, things were happened where you'd get an unsigned affidavit, perhaps, or an unsigned something, and it would be given the day before. And you wouldn't have a chance to look at it. The Supreme Court looked at changing the rules, and it changed these rules to create standards to follow for these dates. In this case, like was discussed earlier, the affidavit, the unsigned declaration, whatever, was filed along with the response. That was timely. That response was timely. It was done. And then when we argued the hearing, it was unsigned. It had never been done. It had never been noticed or refiled with the court. I raised the motion to strike because it was not sufficient under Rule 1.510. And the court struck that. The question is going to be the other side. If you read the hearing transcript, the other side addressed that and said, no, it should be struck. I'm going to be able to later file the signed affidavit. And he did, following in the motion for rehearing, he did file that. But that's not the time frame. Just like when you're in a trial, you've got to do stuff right then. What is the judge supposed to do? If you take a look at the record, you'll see hearing was on November 22nd. The trial was set for December 6th, 14 or so, or maybe 18, 19 days away. How can you reset the summary judgment? If you're allowing new evidence in, you're going to be we got to restart the summary judgment.
Well, I think the argument that the appellant is making here is what's the harm? I mean, what changed materially, if anything, between the version that was filed and the version that was signed and ultimately would have been filed?
Well, they are the same. They are the same. But if it isn't signed, it's not proper testimony. If I'm going to be in a trial and I don't have and I read a statement that isn't an affidavit, like a deposition or something like that, I can't just read a hearsay statement and say, Judge, I know what, give me a couple days and I'll go take care of this problem. I mean, that's what the hearing is for. That's what these rules are for, to create this kind of a time frame and so things can be dealt with orderly about that. So the prejudice is the rules. If you just say every time something like this happens, oh, well, give me a second, give me a day, give me 2 days, I can fix this, there are no rules. Everything is going to be subject to abuse of discretion by following the rules. The rules were put there by the Supreme Court, and they should be followed. Like I said, there was the court is allowed within the summary judgment rules, there's a subsection, maybe D, that says if the court has different avenues, if there's an issue that arises, and one of them is grant the summary judgment. And that is what the court did. There was no request for the other side to do anything other than, Judge, why don't you allow me to do this? And she said no, and then granted the summary judgment as a result. That was if the court allows that as one of the Supreme Court in the rules allows that as one of the manners, one of the mechanisms for the judge to choose, she chose it. So how is that an abuse of discretion if the court in the rules, if the Supreme Court of Florida in the rules say that? So she had the discretion to do that. This was admittedly not within the time frames. Yes, sir.
So the bottom line there is something along the lines of it's hard to say that there's an abuse of discretion when the rules allowed for it, even though there really isn't any prejudice here, because everybody really knew what was going on because they had the declaration before them in a timely fashion.
Well, there is prejudice if you're going to allow hearsay statements to come into the court. That's hearsay. And if they're going to allow new testimony, then the response would be, well, we need to reset the summary judgment timeframes, and the trial cannot go forward. The Supreme Court seems to want these trials to go forward. I'm getting a lot of pressure, like every other litigator is, about getting cases done.
But if there was no material difference between the executed and unexecuted versions, is it really new testimony?
I don't think so. I did not mirror image them, but I would assume that they are the same. And so I would say, if there was a remedy, it would have been a possible asking for a continuance, but that wasn't done. After the court did the permissible thing of striking the affidavit, or striking the claimed affidavit or declaration and moving forward. Next, and here's another issue that if it's allowed, I don't know what the answer is, but I wanted to raise this. If it's something that's allowed, with the DCA, should it just be remanded? If it's something that should be allowed, the matter should be remanded for consideration of the affidavit, if that's what your ruling is. I don't think there should be a ruling based on what the signed affidavit is, if it was designed to, if the court rules that it should have been allowed in. They shouldn't take that fact-oriented step. So that's just my thought about that. There's no cases on this. I took a look at cases, but there's no cases on this issue because everything was allowed. It was like you filed stuff the day before. So the cases I found with unsigned affidavits were from the old rules, where they would hand deliver an unsigned affidavit and then file it in the court, and they would say, hey, this isn't what was filed in the court. Well, it was filed the day before, and that's okay. But so there's no cases interpreting the new version of the rule, only the old version of the rule. So this hasn't really been addressed as far as I can tell. And if I could, I can move on to the other issue of that the summary judgment was affirmed. Okay, in this protected whistleblower case, 112.3187, this inmate or this employee, Mr. Crawford, participated in the incident where there was an abuse of an inmate. He participated by hiding the view of his body camera from the abuse, turned it around, and then he turned his body camera in to the offending officer, the actual batterer. And he didn't tell anyone about that. He didn't report that. The IG, he says that one of his supervisors said, wait till the IG talks to you, and that person denies that happens. But so the IG did get involved. The inmate did complain. He did cooperate. And this is about January of 18. For between January and July of 18, it's private. There's no information about anything. However, Mr. Crawford's indications about the claimed verbal abuse by Patrick aren't limited to that time. Maybe he didn't say the word snitch at that time, but the other verbal abuse was happening. His complaints about that he said to us during the case were about Mr. Patrick were extending before then. But there can be no retaliation until that arrest occurs of Mr. Feliciano on July 5th of 2018. Nobody knew about this. So there's the arrest and there's the release of the notice about the arrest, and Mr. Crawford files three incident reports. The first two are saying inmates are telling me to watch my back, inmates are telling me to be careful. Well, it's a public record. It's a public record what's happened. Word spreads. It's inmates. It's nothing that says Mr. Patrick told the inmates. He's complaining about actions of inmates that are making him scared, not about anything that corrections has done. The third thing, there's a car parked outside my house and I'm scared. Well, this is 3 days. I don't know anything about that. He didn't have any idea, no speculation about whose car that was. There was an arrest 3 days ago. If it was somebody, it could have been the fellow that was arrested. But we'll never know because he didn't do anything except complain that there was a car outside. It's total speculation to say that has anything to do with corrections. So that is the extent of the complaints that Mr. Crawford made
Let me
while he
ask you
was
about
employed.
the actions by the inmates. Are you suggesting that they never could be attributed to the department?
I think it's wholly speculative because what is it assuming? It's assuming that what's the link there? That a supervisor or somebody else at corrections told inmates, and then they said, "Don't threaten Mr. Crawford." Mr. Crawford admitted that he didn't know. It's inmates. It wasn't anybody at corrections. He didn't know where they got the information, but it was public information. It was on the news. There was a press release that talked about it. So, they find out and word spread. Word could have spread about that. But to say that to hang those actions of unknown inmates on corrections is wholly speculative. And Mr. Crawford didn't even do that.
Now, in Mr. Crawford's response in opposition to summary judgment below, he relied on deposition testimony from other officers that, did indicate that the work environment deteriorated, that, his supervisors did call him snitch and other names, and that there were some adverse reactions to him participating in
Right.
the
That could have
investigation.
that could have happened. If somebody called him a snitch, okay. But I didn't see any testimony outside of the declaration that it was, and I don't even know if it was in the declaration, that it was said in the presence of inmates. That it was said, I think it was said possibly in the presence of no one or possibly in the presence of officers. I don't see anything that says that it was, I haven't seen any cases that calls, like as the appellant's counsel said, that snitch is something, if you say it once or twice, it's bad enough and that is an intolerable condition and therefore you get a constructive discharge. There's no cases that talk about that. In this case, regardless of he was concerned about being called that, snitch and other bad words, he never reported it to anyone. If his response is that, well, he was my supervisor and I was scared. Well, the federal cases and state cases on these issues are rife with people being abused by or verbally abused by their supervisors. They've got to tell somebody. Why? Because in the lawsuit, this lawsuit is not against Lieutenant Patrick for being mean. It's against corrections. Corrections he's trying to hold corrections responsible for something that he never reported to corrections. They have to be given the opportunity under the law to correct the problem that they're making, the problem that he's complaining of. He never did that. Instead, he was away on sick leave, and turned in his resignation on August 26th. Now, before then, I told you about the 3 incident reports. You had also asked about the other side, about the reassignment issue, I think, and that was in June. That was before anything happened, before the arrest. So, and that reassignment was simply a reassignment to fill another task. He may not have liked it, but according to Lieutenant Patrick, he was just looking at his lunchbox, doing nothing, sitting down in a chair. And so Patrick said, "Why don't you go fill out this?" He gets mad. There's words expressed, and he leaves. Lieutenant Patrick thinks he's going to go to the gate to fulfill those functions, where in fact he's not. He feels that he has a heart problem or something, and he goes to the hospital. So what happened as a result of that? If that's something that he wants you to consider as a possible work environment or adverse employment, what happened? No discipline whatsoever. Nothing happened about that. Lieutenant Patrick was upset that the fella never showed at his post, but he didn't know that he had gone to get medical treatment. Once there was medical treatment known, obviously there was no discipline given or sought in this case. So at the end of the day, we've got no complaints to the employer about what happened. We've got no adverse employment action by him. We've got Mr. Crawford, who is upset about things that have happened and wants a better job, so he goes and gets another job. So he did not give the employer any opportunity to correct the wrongs that he's complaining of now in front of you. Thank you. Any other questions? Thank you.
Sorry, I'm attempting to be paperless. It's a process. So I first want to start just in the same order that opposing counsel brought up his topics. So he talks a lot about the new 20-day rule, and there is not a lot of case law on that. We've sort of been feeling it out over the last year and a half as to how this is supposed to be applied, and we can tell you from personal experience, those rules are flexible. I've had many summary judgment motions filed 30 days before the trial, or deadlines that have been extended for COVID, like was the case here. So the rules are not, or have
Well,
not been.
it's certainly not a jurisdictional rule.
Correct.
So I don't know if you had mentioned in your brief about the rule of civil procedure that allows for grace in
Yep.
terms of if there is an inadvertent
1.540.
mistake.
We cited, I'm sorry to interrupt you. We cited that as well, and that was actually going to be my next point, was that we have summary judgment rules that give us timing deadlines, but we also have other rules promulgated by the Florida Supreme Court that say stuff happens. And
Right, and for that stuff that happens, though, is that appropriately applied to an interlocutory order of this nature, or is that only for final judgments?
Well, I would say that because this sort of was lumped in with the final judgment and is essentially the cause of it, that they're all just sort of, there was really no additional opportunity to appeal. It all came, the final decision on the motion to reconsider came out with the summary judgment order. Normally, I would say that that's probably a more appropriate venue if that was the only issue, but it essentially ended the case. But that was going to be my next point, that under 1540, we have that a party may be relieved from an order based on excusable neglect or essentially a breakdown in operational functions at the office, which was the wrong affidavit was filed. So if we can be flexible on the summary judgment deadline rules, we can also be flexible on, I'm sorry, the wrong document was filed. And as we've pointed out, it was identical to the signed versus the unsigned version. There were 17 days between the time that was filed and the date of the hearing, I believe, that this was not an issue. The first time counsel below knew about it was during the hearing. Otherwise, I'm sure he would have remedied it immediately or sought some kind of additional venue. And if there's no other questions, moving on to the substantive argument, there is testimony in his declaration that Lieutenant Patrick called plaintiff a number of derogatory names and a snitch in front of inmates. It's at record 612, paragraph 14. He testifies that those words were used by officers in front of other officers and in front of inmates. So there is a connection between what the inmates knew and how they harassed him and the conduct that was, of Lieutenant Patrick and other officers publicly ostracizing him. And counsel does note that 2 of the 3 incident reports reference this very specific issue of being called a snitch. And that was his primary reporting structure, was to file an incident report. This has happened, and it should be investigated and dealt with, and it wasn't. So the department had the opportunity to take some kind of corrective action and didn't, which forced Mr. Crawford to go look for employment elsewhere, essentially for his own safety. And just sort of in summary, he didn't simply go off and find a better job. As he states at the end of his declaration, he had no other choice. Working in this prison environment was no longer safe for him. He went to work every day, literally fearing for his safety, and had to find a job somewhere else in order to remain in the field.
Counsel, let me just follow up on a question that Judge Osterhaus asked opposing counsel, and it really has to do with the standard of review, abuse of discretion here. I'm going back to the procedural question. And can we say that there was an abuse of discretion when the trial court did something that the court was authorized to do by rule? Maybe someone would have done it differently if we were trial judges, but how do we survive that, or how does your argument survive the standard of review?
That yes, it is an abuse of discretion. We cite the sort of reasonableness test. If 2 people could come to different opinions, then it has to have been a reasonable decision. If you look at all of the rules the fact that the timing rules are flexible, and that's been demonstrated in a number of cases, and that the Supreme Court saw fit to create a rule relieving parties from judgments or orders in the case of excusable neglect or mistake, which this could be nothing other than a mistake, to file the incorrect version of the affidavit when we were clearly in possession of the signed version the day prior. If looking at all of those rules together, two reasonable people couldn't come to the conclusion that this should have just been allowed, that he should have been allowed to correct the mistake, file the signed version of the declaration, and move on. The testimony didn't change. This isn't the old rules one day before gotcha kind of law. We attempted to comply with the rules to the best we possibly could, and a simple error was made. And there's a plethora of case law out there that these operational breakdowns or mistakes should essentially not penalize the client, and that we are to decide cases on the merits, not a technicality. Excluding his declaration is just a decision on a technical issue, not the merits of the case, because that's where the bulk of his testimony is.
Okay, thank you, counsel. Thank you to both attorneys. We appreciate your presentations today. The court is now adjourned.
All rise.
I really thought that they were going to, because I thought that both of my
Right?
on a trial verdict.
Right.
And I was like, oh, I'm sorry, but like, this is obviously just going to punt it. No,
Yeah.
they got rescheduled. I was very surprised.
That is interesting.
I assumed that meetings were rescheduled.
Hey, appreciate it.
Yep.
I'm sure the door would have been unlocked. I could have just walked in anytime.
I
Oh, thank you. I got the chair back.
get it. We'll take care of all of that. Yep. I work with half of them. I do that.
Okay.
You'll be fine. Yeah, I'll get some more around.
Yeah. Okay. I'm gonna look now. So
All
let me
right.
and do some practice. I don't want to get there again.
You ain't, you're gonna be just fine.
I know I've been doing it 40 years and never misqualified. It's, you know, when I get a different group, I get kind of nervous.
I'm gonna try to be there to help out. I told Woody that if we get this thing going, I will help the train. But I gotta get my instructor back out. But, I'm gonna try to be there. I know that the 21st, that day, Thursday.
We are too. So,
Yeah, and so that may be a tough one for me to make, but one, the following week, I should be able to make you.
That's why I said the 27th, because I know we're gonna be down there. But
You gonna be
I get nervous, man.
You gonna be fine.
Look, man, I tell you, I've been shooting 40 years, but like your parents, he said, man, you shoot good, you get nervous when you're around people. I said, well, yeah, because when I'm in an active shootout, I don't think I got nobody standing behind me making sure I'm getting it, I'm going, but when you got somebody sort of judging, you know, so.
You can be
yeah, I
fine.
think I will.
Though, have you shot the steel out there at D County? Have you been on the steel at all?
Man, that was 20 years ago.
So, depending on what part of it he uses, there's the 8 plate or 6 plates that are on a road that basically you got 6 plates across, and then somebody else got 6 plates.
Right.
Maybe 3 of those stations, so you may have 3 people shooting at once. The other is, it's like a room. You're standing in a doorway. You really can't see but your head video, because you're standing in a doorway, and there's 5 different, target stands, and a plate will pop up on the one closest to you, and then it'll pop up a little farther away, and then the farthest one will pop up. Yeah. So,
That's not part of the qualifying thing. Oh, okay.
that's just, this one's
That's
fun
just
shoot.
Oh, okay.
Yeah, qualifying.
Okay.
Okay.
That's good.
Now, they did change the qualifying course, and I haven't seen it yet, so I don't know what they changed on it, but something changed. So,
If the elite qualifying. course
Yeah,
change,
yeah,
okay.
if
I
it-
can see it's online.
if they did anything, I would guess they may have thrown the 25-yard line back in,
Oh,
but
okay. Yeah. 'Cause it was thrown out.
I mean,
15.
I can't imagine that they threw any more lines in from the 1, the 3, or the 7. I
Right,
mean, yeah, most of your shooting's gonna be from 7 yards and in, but I can't imagine that I know they didn't go over 50 rounds, so at the most they added 10 rounds, and I think they probably only added 6,
Yeah.
maybe 8 rounds. There's one strand up close that they only did 4 rounds,
Right.
and that may have been 1 yard
That's a
line.
1 yard line.
They may have added 2 more rounds there, and then 6 at the 25.
Okay.
Maybe 6 more at
Say it's
15.
in one
I don't
study,
know.
one time, most police shooting close.
Yeah, it's always in 7 yards or less.
25 out, that's weird. Yeah, but I'm not the best shot, but I've been able to qualify for 40 years, and
You ain't
still
gonna-
is.
you ain't gonna miss.
Yeah, so.
I'll give you, how much you want, 200 rounds enough?
Yeah, oh, man, that's plenty. Yeah, well, yeah, that's plenty. Give me just a couple boxes. I won't go down and shoot 50 rounds in a box.
50 rounds in a box?
Yeah, and I think I've got a box. So,
That's good.
yeah. I'll get them for me, some will be,
I'll pull them out. You're off Thursday and Friday.
Yeah.
I'll pull them out here as soon as I get down in the office.
okay, good, yeah, because I've got so much stuff, I have stuff done, I have a generator.
Yeah? Would you get a whole home?
I got a portable home generator, it's
All
a
right.
Duramax.
All right.
It's a 12,000 XE
Okay.
dual fuel, and it runs my whole house.
You can run off LP or off gas.
Gas, yeah. And now they got a tri-fuel when you run off natural gas now.
Huh.
But it's a little bit more expensive.
Wow.
I only paid $1,400.
Now, will it run the AC?
Oh, yeah. Yeah, see, I put what they call a hard start on my AC, rather than that compressor kicking right in, it winds it up, and when you get full blast, it doesn't bother the generator.
Okay.
It'll get it, but it'll bother the generator down if you don't have it.
Right.
And that cost me a couple $100 just to put that on.
Yeah.
But I got about $2,000 in the whole thing. But it's a big generator, and I got it on the trailer.
$2,000?
That's all I got in the whole thing. I was gonna get a 12, that one that cost 12,000, the whole house.
Right.
But my nephew's an electrician, and he said, why? Because he's gonna do it for me, so you didn't get one like I got. He's got a Champion, which is built on the trailer, on wheels.
I got a
Yeah,
Champion,
and
5500.
55, I think his is like 11,000 or
Okay.
something. He said, I run my whole house. He said, now if you got an electric stove and you run in your air
Right.
conditioner, you might wanna, not run all at the same time because it puts strain on it. But he said, and he got it up and it ran my whole house.
My little one, I can run 2 refrigerators and a freezer.
Right.
I can run the well pump and all the ceiling fans and lights in the house and the TVs.
Right.
And I mean, every outlet is on in the house. I can't run the stove. If we run the microwave, we gotta go turn some lights
Lights
off.
off.
And,
There was something too, he was saying, he said, people said the microwave pulls a lot of juice. And he was saying, the electrician that did mine, he said, yeah, it's 120, and he said it's gonna be like 2 seconds.
right,
Start.
it's that startup load that gets it.
Gets it,
And,
but, he was saying it, but yeah, I got mine from Home Depot, and he said it was $14.99.
Wow.
I paid my electrician, who was my nephew, who was a neighbor, next door neighbor.
Yeah.
He did, he charged me $175. The highest thing on it, the block, what goes into the panel block, keep the name.
Right.
It was like $90, but it's only about the size of this phone.
See, mine, so I'm on Talcon, and Talcon's got a thing called a Generalink
Right.
that they plug into the meter.
Right.
And you tell them what generator you got, and they tell you which setup you need on that Generalink to plug in.
Right.
And then, basically I crank the generator up, I kill all the power to the house, plug the wire into the generator and into the generally,
Yeah.
and then I go when I turn the breakers on that I want.
Right, that's
And it
the
runs-
same way this works.
And, you know, I want one that's automatic,
Yeah,
I want
yeah,
one that'll
yeah.
run the AC. Mine won't run the AC, there's no way.
Right.
But,